How are you all? Still busy with festive season? Yes, class. Am I audible?
Yes, ma'am.
Okay. So I'll just wait for a while so that others can join in and we'll start the class for the day. Shall we begin with the class? Everyone joined? I again see very limited students today. This was supposed to be a very important topic and you need to understand it. This topic, you are going to really get in trouble while you're writing your exam also. I'll just wait for 2-3 minutes more so that everybody can join. Please encourage everyone to join in. Okay, we'll just start the class. We were discussing yesterday in regards to exclusive economic zone as well as the continental shelf. So again, for a quick revision, exclusive economic zone is about okay. So exclusive economic zone, oblique continental shelf. So EEZ is above the landmass which is submerged inside the water in the sea, and the continental shelf is beneath what it is, the seabed area. Okay, so up to 200 nautical miles, it is considered to be exclusive economic zone. And again, for the same reasons, we have the continental shelf. And with the coastal states have some rights and duties over these two, zones of the sea. That is again through this, ETZ as well as continental shelf. The coastal states have been given the rights and duties under the 1982 UN Convention, that is UNCLOS. So articles 55 to 74 are provided for the same. Okay. And the rights are basically in regards to freedom of navigation, submarines, cables, which we just discussed yesterday about fishing. Fishing rights are enjoyed. There is Article 61 and 62 talks about the same, right? And through for navigation also for the exclusive economic zone, we have Articles 58 and Article 87 of UNCLOS. Okay. Is it all right? And similarly for exploring, extracting natural resources like oil, gas, mineral, exclusive rights of exploitation are given, but no right of exploitation is recognized when there are sea lanes, or you can say there are some obligations by the sea that these, these things are not to be done. And then, usage of cables and pipelines. So all the states, the coastal states have the freedom to enjoy laying submarines, cables, and pipelines. And again, the pipeline is subject to consent of the state. Even the nearby people or the nearby states can have the access to it, but only with the pre-notion or a pre-condition set by the coastal state, right? And coastal states, again, they have to lay down the conditions or provisions for entering its territorial seas. Then it's about renewable energies, how to do the installations. It is again exclusive right of the coastal state to build installation and artificial islands for economic usage, right? And there is no right to build installations and artificial islands if there is again conflicting interest, and then it would have to be resolved through the ICJ. Then we were discussing, we discussed yesterday about the right to peaceful passage or transit passage. Again, EEZ generally has the notion that, while we are connecting high seas or EEZ with other areas which are through the international navigation, it is permitted only through the permission of the coastal states, right? And ships shall proceed without a delay, and that would be a just right to passage. They are not allowed to stop there or do some trade or business without the permission, and should not impose any force or use, or any arms and ammunition should not be transferred. It should be a very peaceful procedure, and the strait should be passed through the continuous and expeditious transit. The transit should be quick, and there should not be any halt, or there should not be any transfer of some materials through products, or you can say some export or import should not be done without the information or conditions set by the coastal state. So the right to peace passage, right to transit passage is again with the coastal state. Okay. That is again right to innocent passage. Is it clear? So today we'll be talking about high seas and how high seas are benefited, or how high seas are involved and used for the notion of this law of the sea. So high seas, as we know, that are waters beyond the territorial sea, which is basically free for all to be used. Okay, so while we're talking about high seas, high seas are like the part of the sea which are beyond any national jurisdiction. So what we spoke about before is about those maritime zones which have national jurisdictions, the coastal jurisdictions of, or the states who have the coast have their jurisdiction over these areas or zones. That is territorial sea, and thereafter we have uh, this continental shelf and contiguous zone, and lastly we have the EEZ. So that is the exclusive jurisdiction of the state, which is nation state, and they are under the natural jurisdictions. Whereas the high seas, which are beyond those 200 nautical miles to wherever until the ocean lasts, it is the high sea which is there. So Article 86 of the 1982 UN UNCLOS Convention, this explains that the concept of high seas is not, a part of EEZ or any, internal waters or any territorial sea or any, continental shelf. It is beyond all that. So all these are excluded from high seas. So what is freedom of high seas? So we spoke in the very beginning that earlier it was a policy or it was a fixed rule that again in ancient period, as I told you, seas were a common heritage of mankind. So they are not under any jurisdiction, and freedom of the seas was the ideology for all the usage of the states or the nation states in particular. So in the course of time, with with time, the uses of oceans had been multiplied, and the claims over those seas and seas beds are on the rise. So in the name of these freedoms and high seas developed through the maritime countries, started using high seas for activities such as, again, navigation or military operations, naval military operations, and again, dumping of various radioactive waste, testing of such nuclear weapons, or maybe, sending submarines or exploration, or, equipping or storing nuclear missiles near the coasts. And the freedom of this was actually interrupted and forbidden and challenged while we develop technologically, and with the powerful military states also, they started to recognize the open seas, and for that reason there was a threat to the smaller states, or maybe the states who do not have any coast, the landlocked states. So it had become all the more necessary to adopt the traditional doctrine that is in regards to the freedom of the high seas to the present times and circumstances, so as to adopt the differences between the developed as well as the developing nations, right? So again, as I was telling you about this convention, so this convention, even though it provides for the high seas and its freedom, and that should be exercised. That freedom should be exercised under international law. But the convention also provides that the high seas should be preserved for the peaceful purposes only, and no state is has the valid authority or purport to subject to any part of the high sea, and to try and overpower or seek sovereignty over such a high sea. So high seas are open to all the states. So these are provided under Articles 88, Article 89, and Article 87 of the Convention, that is UNCLOS Convention, right? So whether the states have they are locked, they landlocked, maybe they have a coast or they don't have a coast, they do have freedom of the high seas. So through this freedom provided thereby, they are having freedom of navigation, okay, freedom of overflight, that is they can fly above the high seas, and also to lay submarines, cables, and pipelines under the high seas. Again, also free installations of, construction of islands, or maybe free installations of various products and services. Okay. And also to win a freedom of fishing as well as scientific research. So these two are the latest additions, that is construction of artificial islands as well as freedom of scientific research. Again, this freedom is not absolute and has never been actually applied in absolute terminologies, because it also has the danger of misuse of such a rights. So it has been also qualified because, while we're talking about, state practicing or demonstrating, the coastal state may or may not exercise jurisdiction over the foreign vessels beyond the territorial sea, right? So while we're talking about certain seizure of high seas, there may be some crimes of, or piracy, etc., that are going on in those high seas. So even though they do not hold a jurisdiction, but at times, even if there is some crime which may interrupt the peace and security of the coastal state through the high sea, that nation state or that coastal state may ask for the jurisdiction, because they have the universal jurisdiction in regards to crimes of piracy, right? So thereby high seas may be considered under the jurisdiction of the coastal state if there is some or the other threat to peace and security, or there is a crime of privacy, because these are under universal rules and universal jurisdiction. So these crimes are punishable, and these coastal states may be guaranteed with this jurisdiction, universal jurisdiction. So even UN conventions demonstrate that freedom of high seas is subject to increasing international regulation. So with the advent of territorial seas, contiguous zone, exclusive economic zone, there has been with time those high seas have started to delimit. So these limitations have caused lessen the high seas and its freedom. As we know, again, to 200 nautical miles, there is EEZ, and after that there is high sea. So again, for that purposes, there needs to be some control in regards to pollution as well as scientific research. So the new regimes that are to be followed are in regards to the control of pollution as well as scientific research. So at present, not only the states are free to take the resources of the sea to the seabed, because in international law, conservation as well as cooperation are more important. Right now, if we want to protect the seabeds, we want to protect the seas, or we do not want to pollute the water bodies. we need to conserve as well as cooperate. That is what is required through a legal order, and that is for the benefit of the globe at large. And then in order to balance out the interests, a better balance between the exploitation as well as usage or exploitation or conservation of seas and its freedom, as well as cleanliness of the seas, as peaceful usage of the same, are are interests that are affecting the coastal states. So they are to highlight and protect their coastal states. The freedom of the sea is in regards to this, that they should ensure freedom of navigation, or maybe unhampered by any exclusive claims of the individual states, and there should be freedom of utilization of the sea, and then we need to cooperate and conserve the resources as well as the seas, or the resources that are related to the sea. So what are, what we talk about flag states jurisdictions. So these are, while we are talking about right to search and seizure on the high sea, as I told you, there is no particular jurisdiction that is provided, right? There is no particular jurisdiction that is there for the high seas, because on the principle of freedom of the high seas, there is no jurisdiction beyond 200 nautical miles, that is up to EEZ. So the legal order on the high seas are through the rule of international law, under which every ship on the high sea is required to have the nationality of and to fly the flag of one state. So while you are using the high sea onto your ship, that ship should hold a flag of their nation state or prove its nationality. The general rule is that the state whose flag is flying has complete jurisdiction over the ship and its crew. So whatever happens in the ship, solely the crew as well as the members in the present in the ship will be directly responsible, and that nation state would owe responsibility towards the members as well as the ship as well as the crew. So under Article 94 of the UN Convention of UNCLOS, every state shall effectively exercise its jurisdiction and control while it comes to the administrative, technical, or social matters to that concern. That is what the ship is flying its flag of. So again, I tell you that the flag holder or the ships who holds the flag in the high seas, the ship and the crew will belong to that nationality, and whatever administrative, technical, or social matters that are governing the ship will be held responsible by that state whose flags they are flying. So Article 95 provides for the warships on the high seas. And again, high seas have complete immunity from the jurisdiction of any state other than the flag state. However, this immunity is only for ships that are state owned or operated by state and used only for the government non-commercial purposes or non-commercial services. But this again is an exclusive jurisdiction and is subject to certain exceptions, or is backed by some obligations. Every state does have the right to search and seizure in high seas under two conditions. That is, first one is right to visit. Then the second is in relation to right to hot pursuit. So a right to visit and hot pursuit, as well as we have piracy, which we already have learned before. Then we have broadcasting, slavery, and drug trafficking. So these are the exceptions to the flag state jurisdiction. So the primary two important exceptions are right to visit as well as right of hot pursuit, right? So what is right to visit? So right to visit, again, a warship on the high seas, may board a foreign ship if there is some reasonable ground for suspecting that ship is engaged in piracy, either slave trade or unauthorized broadcasting, or the ship is without any nationality or misrepresenting its flag or refusing to show its flag. Right? So these are the suspected grounds on which the right to visit is at times, refused or may not be granted. To this, it may send a boat under the command of an officer of the suspected ship. And if that, suspicion remains after the documents have been checked, it may proceed to the full examination on the board of the ship. And if that suspicion is found and unfound and proves to be true, then it shall be compensated for the loss as well as damage. And also, if it is not found and the ship has not committed any acts justifying them, then again it will be set free. Okay, this was in under Article 110 under 1982 UN Convention. Right? So, right to visit is only permissible for the high seas within exceptions when it is the reasonable grounds are that, firstly, if it is not engaged in any piracy, slave trade, or has provided unauthorized broadcasting, or the ship is without any nationality or is not representing its flag or misrepresenting or refusing to show its flag, then it will be unauthorized to rotate or revolve that ship around the high seas. And it could be, if there is some suspicion that is there, it would be checked through an officer sent in by the board. And if everything is found to be all right, then it will be set free. And if there is some doubt, it will be there will be compensation and loss, whatever suffered by the or any damage that may have been sustained. It would be guaranteed by the ship who has been sold. So thereafter, what is piracy? As we have already read about piracy before, so piracy is an illegal act of violence or detention or any acts of, you can say, depredation or which are committed with private ends, maybe looting the crew or the passengers, or even the crew or the passengers of the private ship of the aircraft are going to commit some or the other crime, or any illegal act or violence or detention that is being conducted in that particular ship through private mode. So, and that ship is directed on the high seas against another ship or aircraft or against persons or property on board of such aircraft or the ship, as against the ship and the aircraft, any that is outside the jurisdiction of any state. So all these entities, that is the ship or the aircraft or the passengers sitting in the aircraft or people sitting in the ship or the crew or whatsoever, they will be are not under they're not placed under any jurisdiction of any state. So in that concern, piracy is treated as an offense against all nations. So every state holds the jurisdiction over the pirates. So a pirate has always been considered outlaw or that is again considered to be intent to plunder. So Article 105 provides that on high seas or in any place outside which is outside the jurisdiction of any of the nation states, every state may seizure a pirate ship or aircraft and arrest those persons and even seize the property on the boards. the courts of the state provide that carried out with the search and seizure operations on the persons and the property on the boats. So the courts also may determine the action to be taken with regard to the ships, aircrafts, and as well as the property which is it is obtained. So again, this seizure and search is carried out only by warships or military aircrafts or other ships or aircraft that are clearly marked and are identified as being government, as being a part of the government and authorized as well. So act again of piracy may be committed only by the private ships or aircraft. So a public vessel or aircraft may be considered a pirate if it is intended by a person dominant holding some dominant control to be used for the purposes mentioned therein. Right? So generally piracy is done by some private ship or private aircraft. Okay. So then after comes the right to pursuit, hot pursuit. So international law does recognize the right of hot pursuit on the basis that a coastal state cannot be expected to allow a foreign ship to invade or evade its jurisdiction. So by escaping into the high seas. So the hot pursuit of a foreign ship may be undertaken when the competent authorities of the states have good reason to believe that the ship has been violative of the laws of the regulations of the particular state. So what do you understand by hot pursuit is that while we are talking about jurisdiction, what if our sea or the ship commits some crime in the vicinity or the you can say under the jurisdiction of a state, and thereafter it flews away to the high seas because sorry, there is no jurisdiction therein. Thereafter, that would affect the the foreign ship or the right of the coastal state to if that has violated the laws of the sea, then uh, in order to believe and have the state should have a good reason that the ship has violated such a law, and they need to claim the right of hot pursuit, even if uh, it has tried to escape to the high seas, which it cannot do because of the lack of jurisdiction in the high seas. So under general customary international law, as we have read it before also, that this pursuit must commence in internal waters or territorial waters of the pursuing state, and hot pursuit can commence in the continuous zone of the pursuing state. So any crimes that are committed in between the maritime zones, maybe in the internal waters, maybe on the contiguous zone, or maybe in EEZ, or maybe uh, under this EEZ or the continental shelf, and it has tried to escape the high seas or has flown away or driven away, after violating laws and regulations applicable. So the hot pursuit begins only if pursuing ship has satisfied itself by such practical means as may be available that ship pursued or one or the other mothership is within the limit of the territorial sea, contiguous zone, EEZ, or continental shelf. So the pursuit may only be commenced after a visual or auditory signal to stop that has been given at a distance, which has enabled to be seen and heard by any foreign ship. So the right of the hot pursuit may be exercised only and only by the warships, the military aircrafts, or any of such aircrafts or warships that that may clearly be identified as on government service or being authorized in. to that effect or authorized in that manner. Is it clear? So this pursuit is generally done or pursued continued outside the maritime zones of the state if the pursuit has not been interrupted. So this means that hot pursuit is broken off. It cannot be resumed. Also, the right of hot pursuit ceases as soon as the ship, as soon as the ship pursues enters the territorial sea of its own state or any third state. So it is only applicable for the high seas if there is some illegal activity that is conducted on the maritime zone of the nation state or the coastal state, and it will cease to happen once it has entered its own what do you call its own territorial waters, or it has entered its own territorial boundaries, or maybe entered some another state in that regard, and it's not present in the high seas anymore. Is it clear? So there is also a provision in the convention regarding the damages and the compensation if there is any loss or damage that is caused where a ship has been stopped or arrested outside the territorial sea in circumstances which actually do not justify such an exercise of the right of hot pursuit. If such ship, after the investigation, is found out to be clean chit, then it can also claim damages upon the coastal state as well as whosoever came to check or no try and stop or arrest any person therein in the ship. Yes, class, are you able to is it clear to you all? Yes, any response? No response, students? Are you able to follow it? Whatever I'm talking. So the last and the least topic is about the bay. The bay is somewhat of an area of 224 nautical miles in between the two coastal states. So if there is a area of a semicircle, that is, there are two countries, two nation states, and in between them, there is just a difference of 24 miles, 24 nautical miles. Then, as I told you, there is a principle of equidistance. So, the distance between the natural entrance points, if a bay is measured and a semicircle is drawn along the line of that length. So the area of the semicircle is compared to the area of water found landward. If there are semicircle less than the area of the water, then it is a bay. So the distance between the entrance points is less than 24 miles. It may be drawn between them. Otherwise, the closing line can be drawn within the bay in such a manner to enclose the maximum area of water that is possible with the line of that length. So as we started yesterday in regards to if there is a bay that is created that is up to between the distance between the two nation states is just 24 nautical miles, then it has to be divided and the principle of equidistance will be followed, right? And if they will have their territorial waters, economic, special economic zone, exclusive economic zone, as well as contiguous zone amongst the halfway of it. Is it clear? No response, class? Yes or no? Yes, class, and no response. Are you able to follow, students? Okay. So quickly we'll discuss a few cases, and I would want you to listen and also respond. I'll tell you the facts and then you'll have to respond to me. Is it clear? So be attentive, all of you. So I'll state the facts and who will decide what will happen in this case. So there is a foreign ship that is passing through the Indian territorial waters. Okay. So there was a ship that was passing through the Indian territorial waters. I will tell you the name of the case later on. First, you need to solve this. So listen to the facts of the case very carefully. So the foreign ship, while traveling through the Indian territorial waters, was involved with some illicit trade of narcotic drugs. So by that time, Indian authorities could realize that there was an illegal activity. The foreign ship entered the high seas, and the coast guards of Indian naval or the Indian coast guards of the ship pursued and captured it and brought it back to the Indian port for the trial. So, what is the liability of the foreign ship under the 1982 convention? Whether it is responsible or whether it is not responsible, and what is the contention that is to be dealt with? You have to tell me. Yes, any one of you? So if you don't answer, I would ask you to give me the answer of the question in the assignment only. So I'm not going to waste any further time on keep on asking you the same question again and again. If you don't want to answer, I'll continue with the class. So in one case, another case that is about, as we have already discussed about this case, this is North Sea continental shelf case, while in which we discussed about the equidistance principle, if you remember. Do you remember this case or no? We talked about the delimitation if it is affected through the necrement, and if there is an equidistance principles, and that is to be taken in account with the relevant circumstances, and all each of the parties of the this case has to deal with these ideas of continental shelf, that it possess the natural prolongation of the land territory of the another. So this is again a special circumstance in the eyes of the court, and it was held that there is, according to this, the Bay Area has to delimit itself according to the principles of equidistance. And maybe if there is some doubt or some, if there is land territory which has extended to its continental shelf, then it will be treated as a special circumstance. Is it clear, class?
Ma'am.
Right. So, in another case, this is Libya versus Malta case. So, in this case, again, it was held that while we are discussing or demonstrating EEZ as well as the continental shelf, These both are, linked and are, are in consonance with the modern international law. Since we are talking about rights that are enjoyed by the states over its continental shelf, would also be possessed by it over the seabed as well as the subsoil according to EEZ principles. So it can proclaim, and in order to take in account the delimitation of the continental shelf, it is actually permissible legally to extend its exclusive economic zone. And that does not mean that the concept of continental shelf has to be absorbed, and by that EEZ principle will be not recorded. So it does not signify that greater importance must be attributed to elements, and as such distance from the coast are the common to the concepts of the both. So in this again, while we're talking about EEZ and continental shelf, in a few cases, that is again, while we're talking about EEZ and continental shelf, that it is corresponding to their either of the two are interrelated and interconnected. So while we are discussing about jurisdiction and practical reasons, okay. So while we're discussing about legal and practical reasons, the distance criteria of the Bay Area must now be, applicable to continental shelf as well as to EEZ. So there is again a quite provision of the distance in between para. Again, this para is in regards to Article 76 of the Convention. So this case is Libya and Malta case. That is.
Can you type it in the chat box, case
Yes,
name?
I'm doing that. Just give me a moment. 1985 ICJ. Okay. So this was again in regards to the Bay Area of Libya as well as Malta. And they had to decide whether if the water has receded from one end and that the continental shelf has emerged as a land territory. So with that, will it affect the other nation state or the other coastal state in regards to its rights over exclusive economic zone, and whether it is parallel? While we are talking about EEZ, we are talking about above the sea, and while we are talking about continental shelf, it is subsoil or below the sea or the seabed. So whether the distance criteria is now applicable to the continental shelf as well, if we talk about the rights over the exclusive economic zone and the distance apart from the provisions that are enlisted under Article 76. So in this, ICJ held that since the rights that are enjoyed over its continental shelf will be observed and will be possessed as it was above the sea or below the seabed, and the subsoil it might proclaim. However, that it does not mean that the continental shelf has been absorbed by that of exclusive economic zone. It, however, identifies or signifies that there are greater importance that must be attributed to elements such as distance from the coast, which are common to both the concepts. So this is again in reference to the delimitation of the continental shelf. So Libya in this case argued about the natural prolongation of the land territory into and under the sea. And again, as it is still primary basis of the title to the continental shelf, while in the Malta country argued that the distance principle as laid down under the Article 76 of this convention says that each state can proclaim its continental shelf up to just the distance of 200 nautical miles from the coastline, which is actually the truth. So this principle natural prolongation was defined was defined with reference to the physical features or geographical features or geological features. So in this case, it was held by the ICJ that both natural prolongation and the distance are essential elements while deciding the jurisdiction or the concept of exclusive economic zone as well as continental shelf. So it means that where there is a natural prolongation of the continental shelf and it does not exceed up to 200 nautical miles from the shore, it is defined by the reference from the distance of the shore, right? So irrespective of any physical feature or physical nature of the intervening, soil bed or seabed or the subsoil, right? So it was held that the concepts of natural prolongation and distance are not opposed but are complementary to each other. So as and when there is the distance has prolongated or increased, so the natural prolongation as well as the distance from the coast are both relevant considerations while we're talking about delimitation of the opposite continental shelves. So thereafter, while there is a prolongated, continental shelf from the shore, then if it is beyond 200 nautical miles, then it will be not considered. But it is within the 200 nautical miles, then it will be again divided on the basis of the equal distance and delimitation principle, and the both considerations will be considered as complementary and it will not go against the principles of equidistance as well as the principles of Article 76 of the UNCLOS Convention. Is it clear?
Ma'am.
So far, any questions you can write to me and kindly complete your assignment. And also, I would want you to answer the question which I just asked you, that whether if a foreign ship is passing through the Indian territorial waters and is involved with some illicit drug trade, and by the time the Indian authorities realize the same, it has entered, the foreign ship enters the high seas, and Indian Coast Guard ships brought it back and captured it and are deported it to for a trial. So what is the liability of the foreign ship under the Convention of 1982? So you need to tell me the answer in the assignment. So this is your assignment for the day or this week, sorry. Is it clear? So any questions or shall we close with the class?
Questions, ma'am.
More questions? So all of you also complete the last week assignment as well as this is a very small question. I have not given you a larger question. So kindly do the same. Do mail me, right? So I'll just close the class now. Thank you so much and enjoy this weekend. Happy to share out to all of you. We probably won't meet after in this week. Probably on Monday we'll have the class, right? Enjoy all of you.
Thank you, ma'am, and wish you the same.
Thank you so much.